Alrighty, I now call the June 12th, 2017 meeting of the Municipal Code Enforcement Board to order. If all would stand, we'll have the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. General announcements. The city desires to accommodate persons with disabilities accordingly. Any physically handicapped person pursuant to Chapter 286.26 of the Florida statutes should at least 48 hours prior to the meeting submit a written request to the chairperson that the physically handicapped person desires to attend the meeting and accommodations will be made. Any person who decides to appeal any decision of the Code Enforcement Board with respect to any matter considered at this meeting will need a record of the proceedings, and for such purpose may need to ensure that a verbatim record of the proceedings is made, which record includes the testimony and evidence upon which the appeal is to be based. Any person or defendant who requests to review or object to any exhibits presented to the Code Enforcement Board by the City of Titusville prior to submission to the Code Enforcement Board must stand and state their request to review the exhibits prior to review by the Board at the time that their case or agenda item comes before the Board for hearing. Any person found to be in violation of the City of Titusville Code of Ordinances and given a time frame in which to comply shall, upon compliance, be responsible for contacting the Code Enforcement Supervisor for an inspection to verify said compliance. The violation will not be considered to be in compliance until the Code Enforcement Supervisor is notified and verifies compliance. What do we have? 1, 2, 3, 4, 5. 5 members, huh? Good. Quorum of 5 members present this day. Mr. Rogers, would you like to swear in the staff, please?
Do you swear or affirm that the testimony you shall give before this board shall be the truth, the whole truth, and nothing but the truth?
Would someone like to make a motion regarding the minutes of the April 10th, 2017 meeting?
Correction, that is May 8th. Correction, that is for May 8th minutes.
Oh.
So moved, with correction.
Second.
Motion's been made and seconded. Is there any discussion? Roll call vote, please.
Vice Chairman Bell?
Yes.
Member Richardson?
Yes.
Member Edens?
Yes.
Member Grant?
Yes.
Chairman Cunningham?
Yes, motion carries. We'll open old business.
Good afternoon, Board. I'd like to start off today's agenda with case number 1689 for the property located at 503 Cheney Highway. I have here in the audience a member of the staff of the Planning Department who is available for questions if necessary. However, I would request that the Board continue this case for 1 month based on the following update from Mandy Lamoth, Development Specialist of the City of Titusville. She wrote to me on Friday afternoon indicating that Rodney Honeycutt has uploaded plans this morning for a formal pre-application meeting for the golf cart business at 503 Cheney Highway. Mr. Honeycutt indicated that he will be out of town next week, being this week, and has requested a pre-application meeting on June 20th. Staff has scheduled the meeting for June 20th at 2:30 p.m. Based on this update from Mandy Lamoth, I understand that the plans are proceeding along as they can and should at a reasonable rate, and I expect that next month there will be progress after that pre-application meeting occurs on June 20th, at which time this case would be again presented to you, the Board, for your consideration regarding the development that has occurred at this property. And again, I have Brad Parrish here for questions if you have any. the city requests to continue this case for 1 month.
Anyone have any questions?
Is Ms. LaPone, you're all right with that?
I am, but I have something that
If she'd like to speak, I'd like to bring her up to the podium.
Come on up.
Do you swear or affirm that the testimony you shall give before the board shall be the truth, the whole truth, and nothing but the truth?
I do.
And if you'll state your name for the record again.
Yep, Leslie LaPone.
Thank you. Please proceed.
Okay, yes, that's fine. One thing, it was a little confusing last time I was here, and I think one of the members asked, had I ever applied for a building permit? I went through my records, and actually when I was meeting with Brad on the 17th of May, myself and my operations manager were there. We found in the file, I did apply for, I just want it on record.
Oh, okay.
I did apply for a building permit, and that was July 26, 2016. And I just want that entered because I did try to make things right then. So I just want to make sure that this is acknowledged. But other than that, I'm fine with it. And we do have a meeting scheduled for the 20th. So we're good.
July, what date again, please?
It was July 26, 2016.
So it was applied for but never issued.
What happened was from there I got bounced over to planning, and that is where I have remained.
Okay, I see.
Okay,
Thank you.
Thank you.
we good?
Any other questions or discussions? Who would like to make a motion?
I'll do it.
All right.
Per the city request on case number 16-89, we grant a 1-month continuance to our
Second.
next meeting.
Second.
Motion by Pat, seconded by Joe. Any discussion? Roll call vote, please.
Member Richardson?
Yes.
Member Edens?
Yes.
Member Grant?
Yes.
Member Beckles?
Yes.
Vice Chairman Bell?
Yes.
Chairman Cunningham?
Yes, motion carries.
All right, the next case on your agenda is for case number 16-115 for the property located at 5001 River Edge Drive. This case was previously presented to the board in January and continued until this date, as there was a permit that was required for the alteration on the property that was set to expire in the first week of June 2017. Prior to the expiration of the permit, the building department has extended the permit to allow the owner to continue the alterations on his property due to some progress being made on site. Therefore, the city requests to continue this case until your December board meeting to determine whether or not that permit has been completed by that time, which the owner has the right, that next 6-month period of time to complete the work that he has an active permit for.
To December?
To December.
So they're sending 6 months in?
That's correct. That's the city's request for this case. Does the board have any questions?
I see none at this point.
Okay.
Who would like to make a motion?
I move that we, case number 16-115, grant the building department's request for a 6-month continuance on that case.
Better phrase that till our December meeting, I think is.
Okay, to be reviewed again on December 2017 meeting.
Very good. Second. Okay. Motion by Pat, second by RL. Any discussion? Roll call vote, please.
Member Edens?
Yes.
Member Beckles?
Yes.
Member Grant?
Yes.
Vice Chairman Bell?
Yes.
Member Richardson?
Yes.
Chairman Cunningham?
Yes, motion carries. Next case, please.
Thank you. The next case on your agenda is an update only. No action is required for 17-01. The property is located at 1390 Thornton Avenue. This case was continued on May 8th, 2017 until July 10th, 2017. And unfortunately, the city has not received any update from the representative of this property. It will be heard again by this board next month, and hopefully we will have heard more progress by that time. You may recall this is a probate case that we expect to have some time pass before there's progress. So no action required here, and I'll move on to the next case on your agenda, which is 17-33 for the property located at 3654 Sawgrass Drive. I have Code Enforcement Manager Glenn Tullison here to provide testimony regarding this case, as the previous officer is not here today. I would like to invite Code Enforcement Manager Tullison to join me at the podium regarding this case, and the owner is also present in the audience.
Okay.
Let me get one thing, excuse me. Okay. For case 1733, the board previously found violations to exist on this property and ordered the defendant to bring the property into compliance on or before May 8th, 2017. The property is not in compliance as the violation still exists. And Mr. Tullison, have you re-inspected the premises at 3654 Sawgrass Drive to determine whether the owner has brought the property into compliance?
I have.
And is the property still in violation?
Technically, by the code, it is.
And what violations still exist on this property?
Would be a vegetation in height of 12 inches.
Could you please display some photographs on the overhead for the board to review?
This was taken this morning. I met with the defendant in this case, and we walked the yard. As you can see, some of this ground covering here, while it is floral, is larger than, of course, by 12 inches, and that's what the code says. The code also talks about wild overgrowth, which, and I'm going to show you some pictures, as you can see that she's done a considerable amount of work as to when we first saw this case. That actually would have been more like what was back there. And we're getting now to here. I haven't yet proven I got several pictures. Again, now she has said that she has spoke with the contractor and she's going to let them take this hedge down to match the adjoining properties. Once we get it complete. And she is working towards that. As you can see, these pathways have been cleared out, cutting back some of the larger growth. She also now has a new residence in the backyard. We have a gopher tortoise that now resides back there. Picture doesn't do it well, but it's actually very large. And again, as she has been working, and she's been working by herself, and she can testify to that. Again, this was all severely overgrown. It was actually overgrown on both sides. A lot of that's been cut back. And then here's some more work that's done. And again, the pictures don't really, again, there's that hedge that'll be brought down several feet actually from there. Again, these are over, or right at the 12-inch limit, which the code says. And of course, remember that code was written in 1963. Again, this was all overgrowth, and she's working on clearing this all out. Didn't get a good picture here, but the condenser unit that sits here has some overgrowth that needs to be removed so it'll work properly. Again, as you can see, we're working, as we're coming around. Again, these are all flowers. A lot of them are potted. These are growth. That's potted. This is ground cover. And again, not grass, but it's ground cover. And again, more photos. This would be, again, showing the hedge that she's working on. These are flowers, low ground cover. This was what she removed this week, even with all the rain. And that was headed out to be mulched. She can testify to that. Again, she's got growth here of the butterflies, caterpillars. Again, it's Florida state statute actually encourages Florida-friendly greenage. And that all came around in 2009. However, our code hasn't caught up with that yet. Our current code still says 12 inches wild growth. So technically, and I've had that conversation with her this morning, that I would have to testify that technically, yes, it is by the code in violation. However, all of the plants that I found in there were mostly, everyone that I could identify, and I'm not an arborist by any sense of imagination, are on the list of Florida-friendly grasses. She can attest to what she's planted or not planted. So it's up to the board. I'm going to leave it with y'all. Is she's made a lot of progress. It is actually off the masonry walls. The vines are most, again, doesn't meet the code. No.
And so, as I stated earlier, the owner of the property is here. I believe she intends to speak to the board. Does the board have any more questions of staff before we turn the podium over to the defendant?
Mr. Tolson, if she brings the hedges down, she's still some of the plants will still be in violation, the 12 inches?
There would be some of it, yes, ma'am. But it's flowering Florida wildflower.
So does that count toward the code, the city code?
Not the way the code's currently
Okay.
written.
How far off is the city code versus the homeowner's code? Do we know?
I don't have any idea. I would imagine they're here. They can attest what their.
But we're more concerned with our city code, so I'm not worried about it.
Yes, ma'am. I don't know what their deed restriction says.
So the flowers that
But I
over
would-
12 inches are still okay?
Right, and she is an understanding. Now, again, does it match the neighbors? That's going to be no, because they all have manicured lawns in the rear courtyard areas. She does not. She has chosen to go with the friendly Florida landscape. State law allows for that.
But she's also got the pathways which are now cleared. The vines are off the wall, and she's going to cut it down to match the other height. So that's 99%
She is
of
working
about
in
that.
that direction. I have actually even since meeting with her after, I guess it was right after the last meeting when we first came out with Ashley. When I met with you on your property last time, before today?
That was with Ashley.
Yes. There's significant work done since that time. It's like 3 weeks or 4 weeks.
Yeah.
And I did get with the environmental planner here. They're actually looking at the difference of the code with the new Florida landscaping, and there is a new landscape ordinance that will probably be coming around July. And he's going to actually look, and I've had conversations with him about that as far as Florida friendly. But again, the current code doesn't allow that. So, but that's where we're at.
And the tortoise stays.
He's there, yes, ma'am.
And he stays. I mean, there's no moving him out anyway.
Nope,
Okay.
not until he moves on his own.
That's funny.
Anyone else with any questions at this point? Okay.
Thank you, Glenn.
Mrs. Redbari, would you like to come up?
Good afternoon.
How are you?
Not so well, and I apologize for being late today. I haven't been feeling well.
Okay. We need to have you sworn in by our attorney.
Of course.
Do you swear or affirm that the testimony you shall give before this board should be the truth, the whole truth, and nothing but the truth?
Yes, I do.
And you're Leela Ratbari, the owner of the property in question, right?
Yes,
If you'll make your comments directly to the board.
sure. I had some pictures and I had a letter that I left at home. I'm sorry, but
You need to
maybe
pull that microphone closer.
maybe later I have a chance to bring it to your attention. But what I did remember to bring with me, oh, I'm sorry. What I did remember to bring with me today is a copy of the statute that I'm hoping that can help me in this way. We are dealing with two sets of rules and regulations. One of them was created before the awareness that exists now about the environment. And when I'm working in the yard, I'm trying very hard to respect the old rules and regulations that are existing. However, I'm also obliged because I know what is now better. I'm aware of what should be actually probably reviewed. I can't go really completely by the old rules and regulations because I know in certain ways they are damaging the environment. I'm trying very hard to compromise, and I have done a lot of work. I have come forth. I have cut down many things that I was thinking while cutting that I'm actually taking some nutrition away from the habitat there. But I have left some, I have cut some. I'm constantly trying to match the rules and regulations the best I can without too much damaging the other. I'm replacing certain things gradually. This is something that if I had done drastically would have been very wrong ecologically. If I want to leave everything at my pace, it will be wrong because of the code that cannot wait longer. Mm-hmm. I have had a very, very difficult time trying to figure out how to find a solution. And because I was made aware of the statute, I had to consider. May I offer this to you to take a look?
Is that the state statute?
It is a copy of the statute.
Of course, you can submit it. We will not consider it.
The Section 3B and 3C, according to the lawyer that I talked to, they would protect me in this case. They would allow me to have more room to still go by the ecological rules and regulations versus the older rules that were created for the code, I don't know, some years back. Mm-hmm. This is more recent. And the reason this has been created is because there is more awareness there, because there have been many meetings, many people have talked about it, discussed it. It became law gradually. But now that we have this awareness, now that we have this kind of direction, I would not be comfortable with myself not to take advantage of something that is showing us a better way to deal with our environment. Like I said, I have worked a lot to come forth and to come as close as really I can to the rules and regulations that had existed before. I'm still willing to work and talk and compromise and whatever it takes. But to cut everything down just because it was once meant to be the better, now that I know there is more awareness, now that everybody is trying to somehow be more aware of our water reservoirs, of our pollinators that are essential to our foods, all these things that we have discussed. I don't want to take more time on that. Knowing that, I don't think I can compromise much more than I already have. Then I would need to somehow find a legal way, hope that it will help me. I don't know. I'm not very good with these things. I'm not even very good with. I'm not all-knowing about the environment. I just know. I'm convinced that my heart is in the right place. And that when I know something is wrong, I can't do it. Because I will be taking something very important away. But I can work with however means. I'm all willing, I'm all there. But I can't forget the basic reason that is making me be so, not let go of this, because it is important.
I understand. Mr. Rogers, is there anything that would change from the board considering the city ordinances based on?
Yes, there is.
Good.
As was indicated, there is a Florida statute directly on point, 373.185 of local Florida-friendly landscaping ordinances. For the benefit of both Ms. Rodberry and the board, if I can read some excerpts from the state statute. Thank you. Apologize. For the benefit of Ms. Rodberry, Section 3C specifically reads, a local government ordinance may not prohibit or be enforced so as to prohibit any property owner from implementing Florida-friendly landscaping on his or her land. So the state statute preempts the local ordinance.
Okay.
But Section 1B, I think this will balance it back out and promote cooperation and assistance both ways. Florida-friendly landscaping means quality landscapes that conserve water, protect the environment, and are adaptable to local conditions and are drought tolerant. The principles of such landscaping include planting the right plant in the right place, responsible management of yard pest, and proper plant maintenance. So the state statute says it's good for Florida, it's good for all the people in Florida to have Florida-friendly landscaping because it uses less water and it benefits us all. So generally speaking, it's a good thing. But there has to be balance, as I understand the state statute, that yes, you can have Florida-friendly landscaping so long as there's proper maintenance, responsible management of yard pest, and you plant the right plant in the right place.
Yes. May I say something?
Yes, ma'am.
I think I qualify for this.
Okay.
My point to the board is, as Glenn pointed out, our ordinance predates the state statute. It's rather explicit, not to exceed 12 inches. That cannot be blanketly enforced in the city of Titusville. The state statute preempts that ordinance. So,
With specific plants,
correct.
with whatever the state considers to be a Florida-friendly
Each
plant.
property, each plant has to be considered on its own merits as to whether or not it meets both tests. The needs of the people to be protected from vermin and pest and degradation of property values, and the right of the people to plant what they want to on their own property, especially if it's friendly for the environment and will conserve our water. So it's a balancing of both concerns.
All right, then I have a question for our city attorney. Do we have people who are qualified to make the inspection and determination?
That's a tough question. I do not believe that we have an arborist on staff. However, our natural resources planner has sought information from the University of Florida's Agricultural Department that explained a bit of what the Florida-friendly landscaping would include, and even shared some photographs of what a Florida-friendly landscape may look like. And comparing one photograph to another by myself, a non-trained arborist, I wouldn't call myself qualified to. I would say that the code enforcement department is more qualified to make that determination, and that's probably the best staff level expertise that we have in order to evaluate whether that the intent of both the statute and the code have been met. I think that the testimony you heard from code enforcement manager is exactly that the yard is being maintained with the intent of a Florida-friendly landscaping. However, there is an inherent conflict with the 12-inch rule that is provided by our code. And so to balance those two tests, as the board attorney has indicated, I think is in this code board's discretion. It is a gray area, and I think that the progress and the efforts that were made by the homeowner are up to you to determine whether or not that is substantial compliance with the code that was cited for overgrowth.
I have some helpful information directly from the statute in that regard. Paragraph 2 of the statute reads, each, and we're in the St. John's Water Management District, aren't we? We are. Each water management district shall design and implement an incentive program to encourage all local governments within its district to adopt new ordinances or amend existing ordinances to require Florida-friendly landscaping for development permitted after the effective date of the new ordinance or amendment. Each district shall assist the local governments within its jurisdiction by providing a model Florida-friendly landscaping ordinance and other technical assistance. I would suggest contacting St. John's Water Management.
That's correct, and our continued work with our environmental planner, as they do have something coming forward in July, and I have not seen it.
So at this point, they're trying to implement a new ordinance
New
to council
ordinances
by July?
that will, well, I'm not sure where, he just told me that in July they plan on rolling something out. I don't know if that's to go forward to council or
This item has not been heard by council yet, so it would take 3 council meetings, starting with 1 for advisability and then 2 public hearings that would follow advisability. So earliest we could see a new ordinance would be August if presented in July initially.
Do you know if it's going to address the contents of the statute?
it is. I spoke with him just prior to coming in the doors, not half hour ago, sir. And we spoke specifically about Chapter 13 and the 12-inch requirement. So that will be rolled into it.
Okay. Well, it would seem to me if there's a law in process, that it would be prudent to allow some time for those rules to change. But in the meantime, there has to be maintenance to try and balance between what the current law reads and what may be the anticipated law. It may be nothing like what your interpretation might be at this point, or what we interpret as the law that we currently have. So it could be that in the new ordinance, they may say certain plants can only be so high, or certain plants are not allowed to be considered Florida friendly. I know that there are native vegetation lists that are considered to be the correct ones to work with. But quite frankly, we don't have sufficient information right now to really make a well, we do have sufficient information if we enforced an old law, but that'd be kind of like sticking your head in the sand and saying, well, I'm not going to look at anything else except what's on the books right now. And I think that this law is telling us that we can't prohibit native vegetation at this point. We just don't know what we can allow.
I actually interpret it, about he said it balances with the B clause that says that it still needs to be maintained.
Yes.
The origination of these things were to preserve property values for yourself and your neighbors. So even if we wait for the legislation to come out, I'm just curious from code enforcement, is there a possible degradation to property values surrounding her based on her landscaping? Are they exposed to more pests and vermin because of her landscaping?
Well, I made and I saw no signs of vermin, snakes, or anything else in the yard other than there were some butterflies there, as she said. As far as that, with it being cut back, her rear yard fronts a drainage easement. Both sides of her property, she has neighbors, and there's masonry walls between her and each one of them. Now, the front is upkept, very nice, looks just like the rest of the neighborhood. The backyard, she's the only one that has a friendly Florida backyard.
But your concern was some of the plants exceed the height of the wall?
Well, that or encroaching into the neighbors. She's actually took most of those down. On both
Nothing is touching the neighbors.
Right.
Yes, I have already, right
She's
after
already
I
taken
came
that
back.
down, and she said that she would have the back hedge.
Yes, sir. The hedge has not been my responsibility. The maintenance takes care of that. And I have spoken to the maintenance even a few weeks ago. If he wants me to be there, that I will be available to make appointments. If he doesn't think it's necessary, he knows if he just follows the mulch, the pathways, I don't even need to be there, that he can come and cut that taller green wall, so to speak. He knows that. He's aware of that. I'm waiting for him to find the time to do that. And another thing, if I may mention, is that my yard is not visible from any side. It's only my neighbors on both sides. If they really try to peek in, because this wall is thick and kind of tall, if they want to, they can look. But normally, nobody have access to that and nobody can see that, even if it would be something bad there. But I'm hoping that if they look, they will smile and they will think, oh, that's nice. This is what I'm hoping.
I understand what you're saying. By the same token, a law is a law, whether you can see it. If our inspectors go out there and they receive a complaint from someone and they go out and inspect it, we rely on them to come back to this board and tell us whether there is a violation or there is not. It's black and white.
I understand, sir.
Okay,
I
so
understand.
The fact that somebody can or can't see through a wall doesn't really enter into the equation.
I understand. What I'm trying to say is that considering that, I feel more comfortable having a butterfly garden there because I know it doesn't interfere with anybody's comfort or vision, or that I can allow myself to go more with the guidance that I have with the new sets of law.
And I think this may be the way the board goes today, there's a law in the process right now at the city of Titusville level. It would seem to me that it would be very prudent to maintain as closely as we can to the law that exists now, and then in August, if it passes, and by all means, approach council and put input into it if you so desire. Certainly that's what a citizen should do. Then you'll have the parameters of what will be acceptable, because we really don't want this thing to drag on for the rest of the year.
Yeah.
It's not fair to you. It's not fair to your neighbors. And I think the board may consider the fact that there is a new law coming and may say, okay, we're going to kind of just work with it for a little bit and see what we can do to correct it. But we want to get testimony from whomever wants to be heard. So was there anything else you would like to contribute, or do you have any questions of Mrs.
Just
Barberi?
one question. You will make continued progress.
Absolutely. That's
Okay.
what I'm doing all the time. What I'm saying is that I have done a lot of that. I am still working on that. But it may never be 100% nothing over 12 inches because I cut here, then something else grows here. I'm trying to find some kind of a balance. For instance, I cut down a lot of Spanish needles on one whole big area. The things that are visible now in the picture are as a little bit, maybe more than 12 inches, are the patches that I left as nutrition for the pollinators and because if I take everything away at the same time, then I'm taking all the food away. This is where I have the difficulties with myself, trying to find a balance, what to do.
What I'm saying is the wall. You'll make continuous progress towards trimming the bushes down to the wall.
If that's what the inspector is telling you.
Yeah.
I'm sorry, sir, but there aren't any things on the wall. I already have taken care of. I don't
I'll
quite
be
know.
happy to meet with her on site and explain that.
Okay.
Because what they're talking about are your masonry walls. Remember?
The
remember-
masonry?
Yes, ma'am. Remember
Block walls.
when we were looking at the one wall and the growth comes up and you have a hedge that runs along the top of it?
Are you? I'm sorry. Are you talking about the front yard or?
No, ma'am, the rear yard. The two masonry walls on each side.
Yes, yes.
The one that's to the right has growth. You've cut a lot of it off, but there's still growth that runs up the wall.
Around the air conditioning?
No, ma'am, the other side.
Yeah. Okay.
I can meet with you and show you what they're talking about.
Because I trimmed a lot of that.
You did.
This morning even. It is like
You-
Virginia vine. Virginia
Right, right.
vine. Yeah, I trimmed a lot of that
I
this
can meet
morning.
you again and show you exactly what they're
Yeah.
talking about, where Mr. Richards is talking about down the wall. I can take care of it, sir. I understand.
Okay, because
Anyone else
as
that has a
as
question?
far as I'm aware, I'm sorry.
Okay. If
For
you'll
the
have a
benefit
seat.
As much as
Are you finished?
may I say something? As much as I'm aware, there isn't anything touching the neighbor's wall or neighbor's side. As much as I'm aware, there isn't.
Okay.
I
Well, that's
may have
where
missed
Mr.
something.
Tollison
Yes,
will
yes,
he'll
certainly.
point out whatever
Thank
the
you,
case
yes,
is. And Mr. Richardson's point is that we have to keep this thing at least within reasonable parameters for another 60 days from the looks of it to see what the new law says. And once there is a new law, then there'll be parameters, and that's what you're going to have to comply with.
Exactly.
So, what is going to happen in the next 2 months? Will I be able to
You have to
leave the country
maintain.
and come back?
You're going to have to maintain it at the level that that man tells you it needs to be at. If he says these plants can't be hanging over the wall, then you got to make sure that they don't go over the wall. He's going to tell you what is acceptable at this point as an interim measure,
Yeah.
and you need to comply, because otherwise we'll be right back up here again.
Are you
Yeah.
planning on leaving the country?
I'm trying to get my mom here. She is in a nursing home, and I'm concerned to leave her too long in a nursing home. Yes.
So you think that for at least some period of time, you won't be maintaining the premises?
No, I have someone who can help me. I already have talked to someone. Yes. And I still don't know when I'm going to go. I just wanted to see whether there will be a period of time when I can make arrangements for my trip.
I can't tell you that exactly,
Yes.
but we're going to get through our discussions and testimony first, and then I'll be happy to explain what's going to go on.
Okay.
Okay?
So,
This is what she submitted for us to take a look at.
You better get your file.
oh, is this yours? I'm sorry. Sorry, I have one like
Yes,
that.
if you'll just have a seat, and we're going to see if anybody else wants to testify, and then the board is going to decide what to do with the property. So you'll know in a few minutes.
Thank you.
Yes, ma'am.
For the benefit of the board, paragraph 3 of the statute, and also the benefit of code enforcement, and also Mrs. Rodberry and anyone else who's interested in Florida-friendly landscaping, there's a long paragraph of agencies that are going to work together, state, local, of all different stripes that are going to come together to establish guidelines. I doubt there's going to be any rigid ruler change in the law. 12 inches isn't going to go to 14 or 16. It's just going to be guidelines. But the water management districts are mandated to work with various industry leaders, the University of Florida Institute for Food and Agricultural Sciences, the Department of State, all work together to come up with guidelines. So Ms. Rodberry will be able to find for herself the guidelines that say what is acceptable Florida-friendly landscaping for the benefit of nature, but also for the benefit of your neighbors. So it's developing as we speak.
Is there anyone else that would like to come on up? Yes, sir.
Do you swear or affirm that the testimony you shall give before the board shall be the truth, the whole truth, and nothing but the truth?
I do.
And your name, sir?
Bill McMillan.
Mr. McMillan, your relationship to Ms. Rodberry or this property?
I represent the Homeowners Association of Las Verdes, which your property is part of.
Thank you, Mr. McMillan. If you'll direct your comments to the board.
Okay. And first, I'd like to tell you I appreciate your compassion for the environment, and it's admirable. But also, if you ask your neighbors, it's not Florida-friendly landscaping what they're looking at. It's overgrown, like he says. There's vines still on it, but they're losing their property values. The place, it doesn't look good. And she did say she'd like a solution. I was just thinking about it. Maybe we can fence it off with 6-foot vinyl fence or something so that the neighbors don't see it, and cut it down to that level. Because right now, it's just overgrowth, and they're tiny yards, so even that photos don't give it justice how tight all that overgrowth is. And we do have lawn maintenance people, but they won't let us come on the property now. They've put a no trespassing thing. I guess that's been filed with the police department too. So we can't touch it.
You're referring to the backyard?
Correct.
Okay.
And also the front yard needs to be maintained too. The wall, we all have walls in front. There's courtyards, but you can't see our address. We have that on there for, fire departments, people come, that kind of stuff. So there's plenty of overgrowth everywhere. It's just not conducive to the rest of the neighborhood. And if you want that kind of landscaping, you need to go live somewhere where that's appreciated. It just sticks out from the rest of the neighborhood. And this isn't her residence. She owns the property, but as far as my knowledge is, she doesn't live at this residence.
We've heard that testimony in previous
okay.
meetings.
So other than that, that's just, what our concerns is, that it's, we hope that you go by code. It's been dragging on for quite a while. We've even had, when we did she let our lawn guy onto the property. He was only allowed to cut a few branches, and then he wasn't allowed to take the branches up because she said it caused too much trauma for the ants. They had to have a bridge to get back home. So it's we've tried to work with her a lot, but it's just getting a little difficult, and we would appreciate.
Did you follow some of the discussion that we were just informed of regarding state law?
Yeah, and I have that. Her attorney sent it to me. She now has an attorney, and also we did, ill will. He thinks it's a personal vendetta we have against her, but if the shoe was on the other foot, I'd be defending you, if you had a problem with other neighbors, which is what you've caused, the two on each side of you.
This is a discussion with the board.
Sorry, okay.
We're not here.
Okay, anyway, so that's just, we would protect her. I mean, we're just trying to protect our residents. I know she creates no harm or anything, but we do like to keep our places maintained, and there's a lot of leeway there. If it could just be brought to code, that would be greatly appreciated.
That's where we're going to be wrestling as a board as to where is the code and where is it going,
right.
As I indicated. The other factor, and this has come up in prior meetings, is we are not going to address anything that is a homeowner's deed restriction.
Correct.
That goes beyond a city ordinance. So we're here to deal with the city ordinance, and now we have the knowledge that there's a state statute that sort of defeats it.
Right.
Especially
Yeah,
with
and the
native
statute, yes.
vegetation.
Yeah.
Your point is well-founded, and somebody needs to get to the bottom line. What is considered the vegetation that the state's going to allow? And that input needs to come to us as a board in the form of the inspection report and testimony in order for us to be able to move forward. So we're, I believe, at a limbo point right now, other than to try and maintain to the best of what we can balance to current code.
Right.
And await the changes that may be coming by August via the local council. Then that becomes an ordinance, and then hopefully it becomes more of a clarification. So if your association, or as I told Mrs. Radberry, if they have input, then it's their job to go to the council meetings and follow what's going to change and put your 2 cents in.
Correct.
That's how the rules get made.
Yep.
When it gets to this level, it's black and white. This is the law, this is what we enforce. So had that statute not been read today, we'd be enforcing the 12-inch law. But the statute says you can't do that.
Now, is that statute, has that already taken effect? It sounded like right now.
Yes, the statute is taking effect.
It was in just progress. Or
2009.
When, Glenn?
I believe it was 2009.
9?
So that's 7 years and it's still in limbo?
No. The state law was passed back in 9. It's taken 7 years for somebody to recognize that it got passed. So in other words, the city is trying to react to it now. We're charged with primarily city ordinances as our first charge, but we also take an oath to enforce any of the state statutes. And since it clearly says that the cities can't go against that state statute in terms of landscaping, we've got a little bit of a problem right now.
Right, but according to that statute, then there is guidelines that can be followed, correct?
That's what we're going to try to find.
And y'all just got to catch up with them.
Yes, that's what we have, or we're asking staff, I believe at this point, to find that guidance so we know what we're trying to enforce.
So lucky us, we get to be the first one.
So unfortunately, all we can do at this point is try to do a reasonable amount of maintenance. In other words, it's not going to be allowed to intrude all over the place, but that judgment's going to come from code enforcement.
Now, may I ask Glenn, do you think if we finished off with that cement wall, made it like a picket fence, or not a picket, stockade or vinyl, where our neighbors didn't have to see it at all?
I thought there's a wall back there.
It's only partial. I'm sorry.
There's only partial walls, and to be quite honest with you, I didn't even look at that.
Yeah.
It's something I can look at, but currently, I was only dealing with what we were there to deal with.
Right. Yeah, I think that'd be a good compromise since she offered that. I mean, just at least, the walls go like here, then it finishes out where it's open and neighbors can see in, so.
Okay, well, I'll let that in the field.
Then that's all.
We as members of the board are bound by law not to even go out and look at your site, period. Justice is blind. All we can do is listen to what they say, what you say, and what the homeowner says, and then we have to try to make a decision.
Okay.
That's how it works up here.
Gotcha.
It gets interesting.
Yep, it is. Learning as we go.
Mr. McMillan?
Yes, sir.
Paragraph 3 of that statute you want to key on with your homeowners association. If I were you, I'd follow up with St. John's Water Management District and be diplomatic. I wouldn't rub their nose in. It's been 8 years and you haven't come up with a plan yet. I wouldn't necessarily suggest that, but I would inquire what's the status of the plan you're working on.
Yeah, just
and give me more input, because that's what it's going to come down to, guidelines. What's fair?
Correct.
And balance both ways.
Yeah, not that it's just somebody's perception, but what the intent. Okay.
So we're looking for more guidance, I believe, is what this board is probably going to land on.
Well, I appreciate this learning opportunity, so thanks.
Thank you. All right, I'm going to open it up to the board unless there's anybody else that wants to speak. You have anything else you want to say?
No, sir, not at this time.
Not at this time?
It's up to the board to decide what they'd like to do with this case here. If you have questions for me, I'm happy to discuss.
All righty. I'll open it up to the board.
Well, I don't see that we have any other choice other than to at least to continue this until next time.
Yeah.
Well, for 2 months, at least August at least.
No, I don't.
Yeah.
Okay.
Well,
August
and that's not
needs to be
completely
longer
true,
than
Board,
that.
because we possibly could someone could possibly follow up with St. John's Water Management and at least get some sort of guidelines,
Possibly.
which possibly we could enforce by next month.
But I would encourage, I'm sorry, ma'am, if I butcher your name,
Mrs. Redberry.
Redberry, sorry, excuse me. I would encourage you to continue trying to improve your property as much as possible. You do plan on continuing trying to improve your property, am I correct?
Absolutely, I'm always trying to improve.
You-
But my.
Gotta come back up again, please. No, come on back up if you're going to. Unfortunately, everything has to be part of the public record, so you have to be on the microphone.
The reason
Yes.
why I asked.
Yes, sir. I certainly want to improve. Even without all this hearing, I would be trying to make my yard look better and put more decorative things, more attractive things, while maintaining still the basic idea of being a good habitat, good nutrition place for the pollinators. However, I don't exactly know now, at this point, I don't exactly know what to do.
Agreed.
And I'm thankful to Inspector Glenn that has been very communicative and forthcoming. If we can work together, that would be wonderful. But
And that's exactly what the board is asking, is
Yeah.
that you'll work with Glenn for the next couple of months.
Yeah.
And it looks like we're going to wait and explore the new rules rather than trying to just stick our head in the sand and say, cut it down. Because
yeah.
that would be a travesty also. So, but it's got to be a balance. So I'm going to leave it up to Glenn to take charge of this thing and
Yes, sir.
and work with both parties until we can get to these new sets of rules. And hopefully council will do them by August so this thing doesn't drag on.
The statute speaks for itself in stating that there must be proper maintenance of Florida-friendly landscaping. The
Yes, sir,
question
and
is
the-
proper maintenance.
Yes, sir, and I am maintaining that properly, the best I can every day. So maintenance is not a problem. It is the standards, the height,
Right.
the width that is the important, and which plant. And I'm bringing more and more natives. I have only had natives because I let grow the things that grow there. I only maintain them.
And I understand what you're saying, and quite frankly, I believe in native plants and believe nature. They're better than we are at doing the proper things. But the guidelines are going to create what's acceptable
Yeah.
within the native area. And not every native plant, in my opinion, is a good choice in certain locations. You would not want to go into a very small backyard and put a very large native plant that's going to overtake everything else that's in there. So there's got to be some balance in everything.
Yeah, sure.
And it cannot be your opinion of what the native garden should look like. It will have to follow some form of guideline. And unfortunately or fortunately, that's exactly what society dictates anymore. We have rules coming out every day. And the rules change and they improve. Like you had stated, they improve in terms of the types of plants that you can have and that sort of thing. But they're within certain tolerance also. And so there will be a guideline, I would expect, that we will see, hopefully by August, that will give you guidance as to what you can have and how it needs to be maintained, what the heights might be, or however they do that in their infinite wisdom. And then that's one that we can then inspect by and say, yes, we agree, you're in conformance with the rules, or no, you need to correct the following things. So it unfortunately, because of the way laws are, it has to create some form of guidance. And it may not be exactly what you would interpret to be that guidance. And, you know, everyone has an opinion.
Yeah, absolutely.
What we've got to go by is what the law will be. and that's what we hope to gain. And perhaps it's going to be exactly what you want, but we don't know that yet.
Thank you, sir. Thank you very much.
Thank you. All right, board, so what do you want to do? Make a motion.
We're saying that the city of Titusville may have standards by August?
Yes. That's what we were informed, is that they are writing the ordinance as we speak.
I can't see what 2 months means as opposed to 1 month.
Okay. So does someone want to make a motion to continue the case?
I'll make a motion.
Okay.
For case number 17-33, a motion that we continue this case in our August Code Enforcement Board meeting.
Okay, I have a motion. Do I have a second?
Second.
All right, a motion by Ashley, seconded by RL to continue case 17-33 till our August meeting and I'm going to add the portion of our discussion that maintenance as assessed by the code enforcement supervisor.
Yes, sir,
will
that's
be-
what I was going to ask you to please put in the minutes.
That your yes.
Yeah, okay.
You will continue to inspect and see that it's maintained,
Yes,
please.
sir.
Very good.
Roll call vote, please.
Member Beckles?
Yes.
Member Edens?
Yes.
Vice Chairman Bell?
Yes.
Member Richardson?
Yes.
Member Grant?
Yes.
Chairman Cunningham?
Yes, motion carries.
Mr. Chair, before we go forward, procedural question. Do you wish to submit photographs that were exhibited to the board, or do you not wish to submit photographs that were exhibited to the board? I'm not requesting, and I'm just asking.
No, sir. Those were merely for to show
Informational, all right.
informational only.
And Mrs. Rodberry, do you have another copy of the statute you gave to the board? Do you wish to keep your copy of the statute, or do you have plenty?
We have one.
We have.
Thank you. That's okay. If you have a copy of the statute, we'll keep the one you gave us. Nothing further.
Just so if everybody knows, the way that the ordinance process goes in the city of Titusville is that there will be 2 public hearings about the ordinance in which anyone from the public is free to come up and approach the council and make comments and agree, disagree, whatever you want to do with the ordinance. There's also a process by which staff will be working on it before it ever reaches the city council. If you want to find out about that, you can request it. This is an open state where you're allowed to look at what's happening, and you're perfectly within your rights to ask for copies of it in its draft form so that you can see what's coming. Okay? So you have an idea of what's happening and where it's going by the time it reaches city council. Because if you wait until it reaches city council, what's going to probably happen if too many people dilute it one way or the other, it'll go to September, October, November. We're liable to be another 6 months trying to get a law. So the more that you can do to look at it before it reaches council, and then still come up to a council meeting and say, this is our opinion, and you can give them a real-life circumstance of what your perspective is from a homeowners association standpoint and what your perspective is from a homeowner's standpoint. That's the way the laws happen, and it's only as good as the people who participate. If you do not participate, in my opinion, you don't have a leg to stand on. Goodbye. So stick your 2 cents in. That's what it really needs to have. And there are more laws in the city of Titusville and the state than you can shake a stick at. So much so that we're not even sure we always know what we have. And here's the perfect example. There's a law in the books since 2009. Nobody knew about it. Not here. And it didn't come up until this meeting. But I do thank you both for being here and participating in this procedure and recognizing that this board wants to make sure we're following whatever the law is going to be. Okay? Thank you very much. Next case, please.
If the board will allow it, I'd like to take a case out of order.
Is this to convenience a certain staff member?
It is.
Oh, my word.
It's just
Ms.
for
Carey,
one-
how are you doing?
It's just for one case, though.
Okay.
I'm going to have you skip to the first case of new business, number 17-68. And I would like to invite the utility billing manager, Carrie Beatty, up to the podium to add testimony for this case. The case number 17-68 is for the property located at 2800 Starlight Drive. Ms. Beatty, do you monitor the collection of delinquent customer accounts for water service provided by the city of Titusville?
Yes.
And can you provide an update on the status of the account for the property located at 2800 Starlight Drive? Starting with what amount is past due on the account?
Past due amount is $5,231.11.
And when was the account cut off from water service?
It was cut off back in 2012.
And has the meter been pulled?
Yes.
And has there been any communication with the account holder?
We did have, we have not had communication from the account holder, but we have went back out to the property and did a recheck on March 23rd of 2017 to make sure that there was no further utility tampering, and the meter has been pulled also.
What was the date that the meter was pulled? Do you have that information?
The meter was pulled back in 2012. It was cut in 2012, pulled in 2012. We did it, and then we went back out in 2017, and there has been no further tampering, no straight pipe or anything. Meter's just still pulled.
That's one of the tactics they do, is they just connect a bridge?
Yes, yeah, and we actually, we generate reports for accounts that have no meter, that had the meters pulled, and we periodically check them. And this one was checked back in 2016 also, and there were no.
Everybody understand there's a curb stop out there, basically a valve?
Yeah.
And the meter bridges between the curb stop and the water line for the house. So if they put a bridge in, all they have to do is,
Is anybody living there?
I'll get to
Oh.
that testimony when I get the code enforcement officer up on the podium. The water department indicated that there was inspections for a vacancy, but I have more information from the code enforcement officer for you. Are there any more questions regarding the water account at this address?
This is just a private residential account that accumulated $5,000 in billing?
Yes, ma'am, it's residential.
Does that amount include stormwater that has not been paid since 2011?
It does include stormwater. We started billing stormwater back in 2012 on the utilities, so it does include that.
So this bill is not just the water, it's from cut off of 2012 to current with the stormwater stuff added in too.
Correct.
which would be
Refuse and
what,
recycle
another
also.
$150 a year roughly for stormwater?
Thanks.
Do you have any idea
More
what
than
the
that.
bill was at when you shut it off?
I don't understand how
I
it
would
gets
like to-
$5,000.
I would like to
a lot
add
of
one
money.
more component of information that my office has identified. The property is owned by Salvador Flores Rodriguez. According to the Florida Today, it has been deceased since November 22nd, 2011. Officer Crisco will provide testimony regarding there is occupancy at the property. However, the record owner of the property is deceased, and I can submit the obituary, or you can take my word for it. But the city does not know who is occupying the property at this time. The city knows that the owner is deceased, and that shortly thereafter the owner's death, the water meter was pulled, and the payment stopped coming to the city for this property.
I understand what you're saying, and I understand that point. And it somewhat has nothing to do with the case in this respect. This bill was accumulated roughly before this person died, and it's been out there. And I guess as one taxpayer, I look at it as, this is what's making the damn water bill so high in the city of Titusville, is all these unpaid accounts. What? I don't want an answer because it's not something that applies to us, but it certainly is upsetting that this amount of money is stuck out there, and it's never going to get collected, in my opinion. And the city of Titusville taxpayers that do pay their bills are footing the bill for all this.
What was the bill when
We
you
do
shut it
lien
off?
the property too. We lien the property for owners. And we do submit the information to finance to lien the property.
But it accumulated to $5,000.
Yes, I know,
You know,
I know.
The last time that taxes were paid at this property was by someone other than the owner after the owner's death, and that was in 2013.
and it still
Typically-
hasn't had taxes paid?
And taxes may require a tax deed sale in the future. City utility liens have priority over even code enforcement liens and do typically get paid at the transfer of title if it's in a tax deed sale or some other fashion.
That's at
And
least one
unfortunately,
positive.
it's not a near and soon option, but that is oftentimes the case where utility liens that are very substantial do get paid. So the city does collect on its utility liens.
Which is the
although
purpose of us doing this.
This is not the purpose of us doing this. The purpose of this is to notify the public that there's people living in a property without water. And oftentimes, these cases are satisfied by those people living in the property finding somewhere to live that has water, or getting the water turned on so that they have water available to the occupants of the property, which is the issue that we are trying to resolve today, is finding people that do not have water available to their property and finding a solution to that problem.
And why can't they get booted out of the house?
At this time, we are still investigating who is occupying the property. We know that based on Officer Crisco's testimony, which I am about to get to, that there are people living there depositing trash through the dumpster, using our trash services. That's the majority of the information that we have. We haven't gone digging into who is occupying it, although that is part
No,
of
but
our...
I mean, do we even have laws in the city of Titusville that gives the Titusville authorities the power to get them out of there? Or are we stuck with the same thing that a landlord is in Florida?
The representative of the property would be the person responsible for getting the occupants or squatters out. I don't know who is responsible for this property other than the person who is deceased and that cannot be reached. I'd like to present...
Someone did pay the taxes in 2013,
That was the last time they were paid, yes.
and that was someone other than the owner, obviously.
According to the tax collector information, which is just available on the public record.
Once you cut the water off, how much do they owe?
That would be in 2012, the amount that was owed at that time. Do you have that information with you?
I do not have that information, but whenever we move forward with a cutoff, it's normally at 2 bills. So it could be very minimal. It could be higher depending upon how much consumption they use. But I apologize, I did not bring that information with me.
Well, you wouldn't be able to tell what the consumption was if the meter's out.
She could look
Yeah,
back
I
at
can
the
look back
history.
at the records, yes. But I didn't bring the
No,
whole
once
history.
you
with
pull the
me.
meter, there's no way to tell what consumption occurred.
No, in the account. And we can look it up in the accounts because the account has all the history.
The question was the amount of debt at the time the meter was pulled.
Yeah.
Oh, that, yes, I know you can determine that.
Yeah, so it would be a 2-month
So
bill.
a portion of this 5,000 was accumulated based on, there's a charge whether you can use it or not. In other words,
Service
just a
availability.
vacant property is still accumulating at the rate of
Plus
$30 or
late
$40
fees.
a month or whatever it is.
Plus late fees and the
Plus
recording
late
charges.
fees.
The liens have been recorded at this address so that the public record has the database of the record lien that the utilities must be paid because Florida statute.
So the lien is already matriculated on this one.
There has been liens recorded since 2011. I don't know at what amount because the amount does increase over time.
And the lien isn't formulated to pick that up as it goes on, if it's
The lien, it gets recorded in the amount that's due at that time of
At
the
that
lien
time?
recording.
I see.
And is it just stormwater liens?
That's part of it. It's utility consumption, the availability charges, any amount that was due at the time that the meter was pulled could be different charges. It's the combined utility bill together. It gets recorded as a utility lien. Again, working with the police department, the code enforcement department has been trying to develop a partnership to identify the occupants of properties that do not have water service, to provide life safety checks and anything that the city can do to identify who's there and how we can get them assistance to be in a good living situation. And so you know that this is my least favorite case to present to you. I know that it's not an enjoyable one, and the only thing I can say is we are working as hard as possible to find solutions for all of these occupants. That's the goal.
I have a question, and I don't know, I think it's going to come to you, and I brought this up before. If somebody's living in occupying a home with no running water, what prevents the city turning it over to the health department? Because that's a health violation.
I have also contacted the health department. I've contacted the local agency, and unfortunately, their jurisdiction does not include residential homes. I got a very frustrating answer when I made that phone call, but I've reached out to every agency that you've suggested.
That's a harbinger of disease, I hate to tell you.
I don't disagree with you.
Even if there are small children involved.
I've reached out.
So that's a state issue?
I mean, you reached out to social services, the Department of Children and Families.
I reached out to let me see if I have my notes with me.
So there's still garbage collection at that property?
As of right now,
Crisco's indicating yes.
I can invite Officer Crisco. I don't know if I have my notes with me.
And you would want that in this respect. You wouldn't want to leave trash.
Yeah, I know.
And the neighbors, and again, for the same reason that you said it shouldn't be.
yes.
But if there are children involved in any of these cases, if you call DCF and then nothing happens, then call the state representative, something's going to happen.
I would need to see proof also to provide to them, and I don't know that Officer
I
Crisco has
understand.
that for this case, and I'd like to bring up his testimony if you'd like.
That's probably one of the hotter spots you could hit. And I know that from experience of, how it works, being in the business and what their jurisdiction is. And with all of the heat they've been taking, if there are children involved and somebody reports that, they're going to get their fannies out there and I think do something to protect the children at least.
And not even an elderly person that's homebound.
Yeah. And I don't know, we're searching for straw. I just know that, the city of Titusville, by reputation, has the highest utility billing of everyone around here.
In the county anyway.
In the county. And I know why it is, because I've been here for 40 years. And there were things that were done in the past that weren't done correctly, and it resulted in a very, very expensive sewer plant that raised the rates as far as they are. Because we have a reasonable rate for water. We get nailed to the wall on sewer. But when you have things like this, that's an operating cost. And from a businessman's perspective, that's driving the numbers up too. And I know it's not you personally trying to do it or you personally trying to do it, but it's very frustrating to look at these cases. Indeed. And then to realize there's not a damn thing you can really do about it according to what we have in the way of laws.
So it seems.
I'm off my soapbox. I'm
In other
sorry.
words, amen.
Not picking, just frustrated. As you are. I can see the frustration in your face.
Just trying to do my job here.
I know you are, and you do a very, very good job. You both do. I just look at it and say, jeez. Okay. I guess we got to listen to Crisco now, right?
Yes, he is up next. Thank you, Ms. Beatty. I appreciate your time.
Thank you, Carrie.
All right, Officer Crisco, did you have an opportunity to inspect the premises at 2800 Starlight Drive to verify if the property is vacant or occupied?
My original inspection for the notice of violation was on March 27th.
Okay.
I re-inspected it on April 19th, just for violation purposes at that time. We're jumping ahead a little bit here.
So when did you provide the notice of violation to the owner of record by first class and certified mail, as well as posting the same on the property and at City Hall?
3/27.
Can you please submit the proof of mailing and affidavit as to notice into evidence as exhibit number 1?
And then after your initial notice of violation, did you verify with the utility billing department that the property remains without water service from the city of Titusville to determine if the property was in compliance with the violations as cited?
Yes.
And when did you do that?
Don't have the date here.
Second inspection?
There's been a couple of memos back and forth from the water department in our citizen serve that shows that it's still unpaid.
And did you take photographs of the property on any of your visits?
Thrown off course here a little bit, but that's all right. Just in short, with these water cases, you don't see many of them that we close out that are either paid or that we cannot prove occupancy. I only bring to you the ones that, I'll talk police work here, that a preponderance of evidence, somebody is in those premises.
Right.
As far as your question, as far as DCF, there was a couple of cases where I did call that DCF did come down because we had evidence that there was children in there. So we are doing what we could do. The ones that you get, are not questionable, but I feel there's somebody living in there, and we'll show you.
Okay.
On May 30th, the initial inspection was done March 27th, and then after the 20 days, et cetera, I went back to post for code board because I still had a doubt as far as vacancy. So on May 30th, I have the lounge chair in the front.
Well, it's sideways.
Somebody was over there. However, also on May 30th, the trash container was out on the street, and there was fresh trash in it, ice cream container, whatever. This morning's inspection, June 12th, the trash container is again moved out to the street. I say again because on the interior, we have different trash. So you have to, I would assume, not assume, but I'm pretty much confident someone is living in there. I've done some neighborhood check, the neighbors, a lot of people aren't home during the day, but this is just the beginning of our process. We find kids in there or something, I'll report it. If I find somebody, what we can do legally, we'll do it, but that's why the bottom of the barrel is what comes here. We can't do otherwise.
Well, we're going to have to rename you. We'll call you Inspector Clouseau from now on. No, seriously, I appreciate the work.
Techniques.
I think that, we as a board rely on what you tell us and have found it always to be exactly on where it needs to be. I'm just trying to figure out how to get rid of this problem in the city of Titusville.
I have a question. If they've cut the water off, how are they still getting garbage picked up? Because isn't that all in the same bill?
The guy's coming down the block. You don't have red flags hanging up on the buildings that say, "Oh, don't pick it up
You
here."
can take his city cans.
I believe that imposes an environmental issue at that moment. If there's garbage in the can, they remove it. And it looks to me
Well,
like
they're getting away with something. Seriously, we're going to look at this. They're getting away with something for nothing. Or getting something for nothing.
It might at least encourage them to vacate if they had to live in a world of trash.
I would venture to say that there's a number of people trying to figure out how to resolve this. We're just on the
cusp.
We're on the edge of it.
Well, and I'm going to look further into the carts that are out there, the garbage and the recycle cans, because they should not be at the property.
And I don't disagree with you from a
Yes,
dollars and
yes,
cents standpoint. But I was up here thinking, then they're going to do it like they used to do in New York when there was a strike. They'd drop it out of the 40th floor window and it'd hit the curb and pile up 12 feet deep. Then you've got a health hazard for the whole neighborhood. So that's something you have to look beyond just pulling the can, because they'll just throw it out on the curb.
But they shouldn't have the carts there, so they may
shouldn't.
be, I don't know, but they may be from another property too, so
Well, if there's,
we need, I
or
will
they
look
could put it in
further
the
into
neighbor's
those.
garbage can, I guess.
Yes.
But let's face it, they're crafty too.
Yes. And we did have a note on the account back in 2016 that a neighbor stated someone was living there with kids. That was back on August 8th of 2016.
Yeah.
The lawn seems to be somewhat maintained.
Yeah, I mean, overall, the property's fairly well
I guess electricity's still on.
upkept.
Well, someone has to live there to maintain the lawn.
And let me ask again, what date did you cut the water service off?
2012.
We cut the service off back in, it was February 8th of 2012.
And you said the taxes have not been paid since 2013, or that's the one that you're aware of?
That's the last time that the tax record has showed that the payment was made, but not by the owner. It shows on the receipt that it was paid by a different individual.
And
So somebody's messing around. The other thing that comes to mind is that on some of these properties, they probably have a well, and they're getting the water from the well.
Officer Crisco identifies verified wells and closes out those cases that have wells when he finds those throughout the course of the investigation of the case. That's not uncommon.
Closes them out. What do you mean?
Before getting to the code board,
Yeah.
certain cases are closed if there's an approved well at the site.
Approved well.
Right.
If I could, Mr. Chairman, actually, Investigator Crisco goes out and verifies with the county that is a active well and has been certified. So
What
there
about the
are.
old ones? I got a well on my property. I'm sure it doesn't have an approval from the county from 40 years ago. Go ahead, cite me.
But no, typically.
Yeah, nowadays we do. Everyone is, you get a permit for a well, you drive the well, and the county's tracking them. But, 30,
But
40 years
again-
ago, and that house is every bit of 40 years old.
It very well could be, but we have run across several homes that are on an active well, actually.
Because if I remember the regs correctly, you're allowed to have, if you want to have a well, there's nothing in the ordinances that say that you can't, but you're going to pay for sewer and you're going to pay for garbage.
Correct.
So it is legal to use a well.
Absolutely. No, but the problem
It's
is.
not legal to not use sewer.
Correct.
Please.
would you repeat what the total amount owed is?
Yes, sir. It's $5,231.11.
Don't forget the 11 cents now.
Does the city have the authority lawfully, I do not know, to foreclose on a utility lien?
I believe that we do. We would have to look at the homestead exemptions and other things that may apply to the property before we proceed with that. But with any judgment, yes, we have that ability.
Well, you indicated the record owner is deceased,
That's
so it's
correct.
not his homestead.
So we're looking at paperwork that was served to a deceased person, right? Meets the statute, I agree, but there's nobody that's going to receive it. So
This is not the
do you
first
think
time
maybe
that this has come up.
in going forward, that's one of the things, we're learning as we go.
Absolutely.
All the loopholes. Make a new change that, will hopefully preclude this from happening in the future.
I'll definitely look into it.
And, give the staff the ability to deal with this.
Right.
I'm sure some of this came about because there were no rules that you could jump on to straighten it out.
Actually, what is being discussed it sounds that it's worse than is being discussed. If the property taxes have not been paid since 2013, the city is deriving no revenue from this property.
Right.
No one is. So that's why I ask about the ability to foreclose on the utility lien, because this problem needs to be resolved one way or another.
Have to go up with a special prosecutor.
Thank you. And if I may invite Officer Crisco up to finish his testimony, I have a few more
Sure.
things to submit to the board. Thank you. Officer Crisco, based upon your inspection, did you file a complaint?
Yes,
Do you have a copy of the complaint and a notice of this hearing that you issued to the owner by record of first-class mail, certified mail, posting the same on the property and at City Hall?
yes,
Do you have an affidavit as to this notice?
yes, I do.
Please place the proof of notice and affidavit into evidence as Exhibit Number 3. Officer Crisco, do you have a cost recovery statement detailing the cost incurred in bringing this case before the board?
Yes,
And what is the amount?
$410.26.
Please place the cost recovery statement into evidence as exhibit number 4.
Okay, so. Costs get recorded as a lien also?
That's a separate lien. That's part of the code enforcement final judgment, that once the board assesses those costs to the owner of the property, then those costs get reported as part of that lien. It's separate from the utility lien.
Separated?
Yeah.
But in this type of case, we're not assessing a fine, we're just going to be assessing costs?
At the end of the case, that's what I would ask, yes.
Okay. So then when that comes back to us,
Next month.
that it goes back to you and
3
then you
months
can
later.
record it?
Yep.
Have you ever seen any vehicles at this property, Mr. Crisco?
Officer Crisco, have you seen any vehicles at this address?
No, you would have had a picture of it if I did.
I thought I would, yeah, okay.
But I think he found enough that looks pretty conclusive, there's something going on there.
And he will continue to monitor before the next board meeting, looking for vehicles.
The dead of night.
I believe that code enforcement manager also tried to attempt contact with each of the properties that have a water case listed on the agenda, and no one answered the door.
They're good, huh? They've got the process down tight.
Yes, sir, they do.
Are there any other questions for staff?
Anybody? I think we got it.
Thank you.
Thank you. All right, who would like to make a motion?
I'll make the motion.
Okay, thank you.
I move that the board issue the following findings of fact in case number 17-68 relating to the defendant Salvador F. Rodriguez. The defendant was properly notified of the violations as alleged in the complaint. The defendant is the owner of or in possession of the real property located at 2800 Starlight Drive, Titusville, Florida. The defendant is in violation of all of the sections of the Code of Ordinances of the City of Titusville as listed in the complaint.
I have a motion, do I have a second?
Second.
Motion by Gina, seconded by Joe. Any discussion? Roll call vote, please.
Member Grant?
Yes.
Vice Chairman Bell?
Yes.
Member Richardson?
Yes.
Member Edens?
Yes.
Member Beckles?
Yes.
Chairman Cunningham?
Yes, motion carries.
Next motion.
I'm trying to remember how we do this.
Next motion.
What do we do?
What are we going to do?
7 days or 2 days or 1 day?
It's within your discretion how long you wish to give to achieve compliance with the deceased property owner.
True. Thank you, sir.
Shorter the
You
better.
pointed that out to me.
Wake of the dead.
No, I'm just thinking though in terms of process, because we're talking, if we do the motion now, then next month it can go back to the city to file the lien?
Can you move that quick? I don't think you can move that quick, can it?
Yes, you can render your final judgment at your next board meeting. I would recommend you give as the law requires, a reasonable period to achieve compliance in your discretion, and then order as you usually do that the defendant appear before this board to show cause why the board should not render a final judgment due to continued violation.
Okay. Got it, Gina? Know what you want to do?
I'll give them 2 weeks. Ready?
Yes, ma'am.
I move that the board issue its order to correct relating to the defendant Salvador F. Rodriguez. Adjudging the defendant to be in violation of the section of the Code of Ordinances of the City of Titusville is determined in the findings of fact. Giving the defendant until 9:00 a.m. on June 26, 2017 to correct the violation to the written satisfaction of the code enforcement officer or to appear before this board at City Hall, Titusville, Florida on, what's the next meeting?
July 10th.
On July 10th, to correct the violations to the city of, to the written satisfaction of the code, wait. No, let me start that whole sentence again. giving the defendant until 9:00 a.m. on June 26, 2017, to correct the violation to written satisfaction of the code enforcement officer or to appear before this board at City Hall, Titusville, Florida, on July 12, 2017, to show cause why the violation has not been corrected and/or why this board should not proceed to impose a fine for the violation. The defendant is ordered to pay $410.26, which represents the cost incurred by the city of Titusville to bring this case to the board.
I'm sorry, did you say July
July 10th
12th?
Yes.
is our board meeting.
Should it be 10th?
It should be July 10th.
Thank you.
Thank you.
Second.
All right, we got a motion by Gina, seconded by Joe. Any discussion? Roll call vote, please.
Vice Chairman Bell?
Yes.
Member Richardson?
Yes.
Member Grant?
Yes.
Member Beckles?
Yes.
Member Edens?
Yes.
Chairman Cunningham?
Yes, motion carries. Thank you, Carrie. We'll make sure we give you special privileges next time, too.
All right, I believe that we left off on case number 17-38 for the property located at 511 Canaveral Avenue. This case was originally heard April 10th, 2017, was continued until July 10th, 2017, and the board requested an update from the owner on this property, and there is no update to provide to the board from the owner on this property. No action is required at this time. The case will be heard again next month.
I'm not sure I remember what.
You were out that day, I believe.
If I could, Mr. Chairman.
I was absent?
Oh, gee, I wonder who was in charge.
But to bring the chairman up to date, actually, the uncle of Mr. Jordan came in and provided testimony to the board that he was going to attempt.
I remember that.
Yes, sir, you
That
were
was
present.
I was in the first discussion then.
Yes, sir.
Okay, so it's just kind of,
Right. I'm not sure that they're going to be able to get that property up, but there are, it is part of the historic area as well, so there are some other entities looking at it.
okay.
Yeah, I remember that.
So at this time, we need to continue the case, is that
No
right?
action is
No,
required
no
at this
action.
time.
If it's not
It's
supposed to
going to
be
regularly be
July,
heard at the next hearing.
I think it was my idea to have them come in.
It was.
Okay.
Mr. Chair, it's continued until July the 8th. The
Okay.
board, in its prior decision, ordered progress reports until July 8th. 'Cause
All righty. I'm sorry to be so backward on it.
No worries. Next case on your agenda is number 17-44 for the property located at 4605 Alpine Lane. The owner has made some progress, and the city wishes to continue this case for 1 month.
Who would like to make the motion?
So moved.
Okay, Pat? Who would like to second?
Second.
Ashley.
Yeah.
Motion's been made and seconded to continue case 1744 till our next regularly scheduled meeting. Any discussion?
At the last meeting, it was stated that there was no contact since April 27th from the owner. Obviously, they've contacted you since then.
Officer Crisco is here to provide testimony if you'd like to hear it. He has informed me that he received an email on June 6th and that 2 of the violations are in compliance as of a June 6th inspection, the junk and debris and overgrowth, and that the owner has contracted with Rodriguez Contracting to demo a portion or all of the property, which would put it in compliance. However, we have not seen a permit for that work to be done yet, so we are continuing the case to allow the next step to take place.
As I
Okay,
recall,
thank
is this one the one that backs up to the mobile station?
Officer Crisco, could you come up to the podium?
Rodriguez, huh?
That was the name that was provided by the owner.
I don't recall.
Any relationship?
I doubt that. I doubt it.
He's dead.
Salvador. Salvador's coming like this demo.
I'm sorry?
Is this the
Stranger things have
piece of
happened.
property that backs up, I think, to the mobile station on Highway 50?
Yeah, it's
Okay.
yeah, mobile, I'm sorry, yes, right behind it. And the reason it's kind of hard to contact because the owner's in Australia.
Yeah, I recall.
Must be nice.
case off the agenda, did you want to wait to the end or pick that one
I'll
up?
do that at the end of old business.
Okay.
All right, so I just need to do a roll call.
Or we could do it now, but yeah.
Yeah.
Roll call, please.
Vice Chairman Bell?
Yes.
Member Richardson?
Yes.
Member Edens?
Yes.
Member Beckles?
Yes.
Member Grant?
Yes.
Chairman Cunningham?
Yes, motion carries. Next case, please.
The next case that's listed on your agenda, number 17-61, for the property located at 2705 Redwood Ave. This case, the city requests to continue for 1 month. This is, again, one of the water cases, and the homeowner appeared and made a substantial payment, but the case is not closed yet. The case will be continued until next month. Hopefully, we'll have it closed at that time.
Any questions? Who would like to make the motion?
So moved.
Motion by Pat, seconded by
Second.
Gina. Any discussion? Motion is to continue case 17-61 until our next regularly scheduled meeting. Roll call vote, please.
Member Richardson?
Yes.
Member Edens?
Yes.
Member Beckles?
Yes.
Member Grant?
Yes.
Vice Chairman Bell?
Yes.
Chairman Cunningham?
Yes, motion carries.
The next case on the agenda, number 17-50, for the property located at 144 Roosevelt Street. The city wishes to continue this case for 1 month.
Any questions?
So moved.
Motion by Joe, seconded by
Second.
Ashley. Any discussion? Motion is to continue case 17-50 till our next regularly scheduled meeting. Roll call vote, please.
Member Edens?
Yes.
Member Beckles?
Yes.
Member Grant?
Yes.
Vice Chairman Bell?
Yes.
Member Richardson?
Yes.
Chairman Cunningham?
Yes, motion carries.
Case number 17-51 for the property located at 192 Roosevelt Street. Again, the city wishes to continue this case for 1 month.
And the presumption is that there is progress.
That's correct.
Okay, in all of these. Okay. Who would like to make a motion on this case?
So moved.
Second.
Motion by Pat, seconded by Joe, to continue case 17-51 till our next regularly scheduled meeting. Any discussion? Roll call vote, please.
Member Beckles?
Yes.
Member Edens?
Yes.
Vice Chairman Bell?
Yes.
Member Richardson?
Yes.
Member Grant?
Yes.
Chairman Cunningham?
Yes, motion carries. Next case.
For case number 17-55, the property located at 550 Titus Street, the city wishes to withdraw this case due to compliance.
You're on a roll here.
For case number 17-56, the property located at 4100 Alpine Lane, I'd like to invite Officer Hutchings up to provide testimony for this case.
Good afternoon, Board.
How are you, sir?
I'm doing well, thank you very much for asking.
Wonderful.
Officer Hutchings, did you have an opportunity to inspect the premises at 4100 Alpine Lane?
I did.
When did you first inspect?
My first inspection was actually a follow-up from Officer Tovey in going through. The initial inspection was done on 3/1/17. I went out as far as this morning.
Did you find this property in violation of the Titusville Code of Ordinances?
I did.
And what was the nature of the violation?
The nature of the initial violation is still standing. It was 6109, subsection 304-1, 6109, 304.10.
And did you provide notice of the violations to the owner of record by first class and certified mail, as well as posting the same on the property and at City Hall?
Yes.
And do you have a proof of mailing and affidavit attesting to this notice?
Yes.
Please submit the proof of mailing and affidavit as to notice into evidence as exhibit number 1. It might also be a complaint.
Yeah.
And And Officer Hutchings, at your reinspection, did you determine that did you determine if the property was in compliance with the violations as cited?
Yes.
And did you take photographs of the property?
Yes.
What do these photographs depict?
These photographs depict the initial inspection.
And are they a fair and accurate representation of the condition of the property on the date that they were taken?
Yes, as far as looking at it this morning, yes.
Can you show us what these photographs show?
This initial is on the back porch, which is also visible from the roadway. As you can see, the dilapidated and very dangerous decking through here.
Oh, it's a wood deck.
What's left of some.
What's left of
Yes,
it?
sir.
Looks like they put in new windows.
A little bit closer, perhaps,
Yeah.
microphone, so you can see it just a little bit more. And dilapidation of roof, awning, soffit area and fascia.
Is that tarps on it?
Yes, sir.
Okay.
Another an overview, taking a little further back. And some more photos as such. With the dilapidation, again, of the soffit fascia.
Okay,
and
and
the roof area.
up there where the satellite dish is?
Yes, sir.
Thank you.
All right, thank you. Can you please submit the photographs into evidence as exhibit number 2?
And the date of these photographs are?
The dates of these photographs are 6/6/17, sir.
And based upon the inspections, was a complaint filed?
Yes.
And did you issue a copy of the complaint and a notice of this hearing to the owner of record by first-class certified mail posting the same on the property and at City Hall?
Yes.
And do you have an affidavit as to this notice?
I do.
Can you please place the proof of notice and affidavit into evidence as exhibit number 3? And just to go over this one more time, as of today's inspection, did the violation still exist?
Yes.
And do you have a cost recovery statement detailing the cost incurred in bringing this case before the board?
I do.
And what is the amount?
$375.04.
Please submit the cost recovery statement into evidence as exhibit number 4. We're happy to answer any questions if you have any.
Is anybody living in there?
We'll probably have
Not
to pass
that
the
I can
stuff
tell,
down.
no, ma'am.
I'm sorry, did you say it's unoccupied?
It appears to be.
Do we have any idea
Yeah,
whether Walter Ferrero knows of the violation?
Have you had any communication with the owner?
No, not at this time. I'm sorry. I apologize. On 5/8, there was, and requested an extension, which was granted, but there has been no movement forward.
The owner asked for an extension?
Correct.
How long was the extension that he requested?
I'm sorry?
Do you know
That's a
how long
new
he
generation
requested the
shingle.
extension
Typical is going to
for?
end up being either 10 to 20 days. If there's been no progress, and up to the point of this meeting, that if there's been no
Yeah, that's a little
progress, then we
holy.
move forward, obviously, with the case.
Okay.
And Pat, you're right, it does look like there were replacement windows and doors.
The city sent certified mail, which came back as unclaimed on its second notice, and previously it said unable to forward, which means the owner chose not to pick it up when it says unclaimed typically.
So we can only assume he's aware of the violation based on the posting at the property.
Correct.
The board continued this case last month to give the defendant an additional period to achieve compliance because of that request.
Any other questions of staff?
So maybe he's trying, but who knows? Because look at, in these pictures, you know, it's got the old windows still and the blinds up where the new windows have no blinds.
Yeah.
So maybe he's trying, but maybe he disappeared.
Need a nudge. Need a nudge.
The windows weren't in violation, all right. I would prioritize.
If there are no other questions, who would like to make a motion?
Thank you.
I'll give it a stab.
All right,
It's the
Ashley.
second reading, it's the second reading.
Will this be initial finding of fact or a
This will
second?
be the second. Huh?
This is the first, it was the
Is
first
it first?
presentation.
The case
Oh,
was
okay, it's the
continued,
first.
but
Okay.
not, there was no finding.
Okay.
I move that the board issue the following findings of fact in case number 17-56 relating to the defendant Walter O. Ferrero. The defendant was properly notified of violations as alleged in the complaint. The defendant is the owner of or in possession of the real property located at 4100 Alpine Lane, Titusville, Florida. The defendant is in violation of the following provisions of the Code of Ordinances of the City of Titusville. Section 6-109, property maintenance, subsection 304.1, exterior maintenance, subsection 6-109, property maintenance, and subsection 304.10, stairways, decks, porches, and balconies. I move that the board issue its order correct relating.
Whoop, whoop. Gotta wait,
finish.
gotta
You got it.
get past
Oh,
that.
the defendant is in violation of all of the sections of the Code of Ordinances
Nope.
of the City of Titusville.
Ashley, hold up for a second.
Oh, okay.
We got to make a motion on what you did
Oh,
at this point.
okay.
So I need a second.
Second.
Okay. Any discussion? Roll call vote.
Vice Chairman Bell?
Yes.
Member Richardson?
Yes.
Member Grant?
Yes.
Member Beckles?
Yes.
Member Edens?
Yes.
Chairman Cunningham?
Yes, motion carries. Now, Ashley, we need a order to correct.
Okay. I move that the board issue its order correct relating to the defendant Walter O. Ferrero, adjudging the defendant to be in violation of the section of Code of Ordinances of the City of Titusville as determined in the findings of fact, giving the defendant until 9 a.m. on July the 10th, 2017, to correct the violations to the written satisfaction of the code enforcement officer, or to appear before this board at City Hall, Titusville, Florida, on July 10th, 2017, to show why the violations have not been corrected and why this board should not proceed to impose a fine for the violations. The defendant is ordered to pay $375.04, which represents the costs incurred by the City of Titusville to bring this case before the board.
Second.
Motion by Ashley, seconded by Gina. Any discussion? Roll call vote, please.
Vice Chairman Bell?
Yes.
Member Richardson?
Yes.
Member Edens?
Yes.
Member Beckles?
Yes.
Member Grant?
Yes.
Chairman Cunningham?
Yes, motion carries. Good job, Ashley.
Thank you.
The next case is number 17-58 for the property located at 1150 Overlook Terrace. The city wishes to withdraw this case as it is in compliance. Next case is number 17-66 for the property located at 4485 Gray Avenue. I'd like to invite Officer Crisco to give us his update. Officer Crisco, case number 17-66 for the property at 4485 Gray Avenue. The board previously found violations to exist on this property and ordered the defendant to bring the property into compliance on or before June 12, 2017, and to pay the costs of $586.36. The property is not in compliance as the violation still exists. Have you had the opportunity to re-inspect 4485 Gray Avenue to determine whether the owner has brought the property into compliance?
Yes, I did this morning, and it's still in violation.
What violations still exist on this property?
Under 6109 property maintenance, 301.3, the vacant structure, 302.7, the accessory structure fence, the 304.7 roof and drainage, and 304.1 exterior maintenance.
Does the board have any questions?
I think not. I think we'll move to motions.
Thank you.
Thank you. Who would like to make the motion? This would be continued violation.
can try it again.
Okay.
I move that the board issue the following findings of fact in case number 17-66 relating to the defendant MWIAR LLC.
Very, very good. I wouldn't have attempted that one either.
The defendant continued to be in violation of the following subsections of the Code of Ordinances of the City of Titusville on June the 12th. Today's the 12th. June the 12th, 2017. Section 6-109, subsection 301.3, subsection 302.7, subsection 304.7, and subsection 304.1.
Okay.
Second.
Motion was made by Ashley, seconded by RL. Just to point out too, Ashley, under subparagraph B, in continued violation, that's the shortcut to say just all of the,
Okay.
that's your discretion, but I just wanted to point it out.
Okay.
Any discussion? Roll call vote, please.
Member Richardson?
Yes.
Member Edens?
Yes.
Member Beckles?
Yes.
Member Grant?
Yes.
Vice Chairman Bell?
Yes.
Chairman Cunningham?
Yes, motion carries. We need the next motion on final judgment assessing fine.
I move that the board issue its final judgment assessing fine and imposing lien relating to the defendant MWIAR LLC based upon the findings of fact issued this date, and that the judgment contains the following provisions. The defendant is assessed and ordered to pay a fine of $586.36.
No.
Per day.
That's
This
your
is per
cost.
day.
You have to determine anywhere from $0 to $250 per day.
Per violation per day. Per
Okay.
violation per day.
Per violation per day. $100 per day
Per violation.
per violation. The violation of section 6-109.
You don't have to expand on it.
Okay. The fine shall commence on June the 12th, 2017, and shall continue until the code violations have been corrected to the written satisfaction of the code enforcement officer.
Second that.
Okay. Ashley, RL.
Where do you say cost?
Just to make sure, Ashley, the way that works now is that'll be $400 a day. That's what you want for a motion?
Yes,
Okay.
as long as everyone else.
Any discussion? Roll call vote, please.
Member Edens?
Yes.
Member Beckles?
Yes.
Member Grant?
Yes.
Vice Chairman Bell?
Yes.
Member Richardson?
Yes.
Chairman Cunningham?
Yes, motion carries.
Chelsea, before you go to your next case, I just bring to your attention again what you indicated before. The legal description of this property, as was on the complaint, as was on the prior decision of the board, and as will be on the final judgment, contains an asterisk, because I understand I'm running into that too. The property appraiser's office has been having some difficulties with legal descriptions. So you're not going to have what I would consider an accurate legal. I just, if you have
I
to
spoke with the
foreclose.
property appraisers, that's actually the way that they're going to start filing all of them in the short form.
And just stay with those asterisks from here on?
That's what their plan is.
That's also what I've been told.
All right, well, I'll leave it to your discretion as to the requirements for an appropriate complaint for foreclosure, if you ever get to that point on this one or any other.
Okay. Thank you.
Board, we're going to take a short break.
Okay. It is.
All right, we are going to come back into session. We've conducted one case of new business at this point, and we're going to proceed with the rest.
But before we get into new business, I have one old business item that got left off the agenda I'd like to wrap up at this time.
Okay.
Case number 17-36 for the property located at 712 Lucky Street was left off of your agenda. It's not printed. However, it should have been on your agenda for today for its second hearing. And the property has made progress. The property has obtained a demo permit. I'd like to continue this case that's not listed on your agenda, case number 17-36, for 1 month until your next scheduled board meeting, and you'll hear that case at that time if you do decide to continue it.
So moved.
Motion by Joe, seconded by Pat.
Yeah.
Any discussion? Roll call vote.
Member Edens?
Yes.
Vice Chairman Bell?
Yes.
Member Richardson?
Yes.
Member Grant?
Yes.
Chairman Cunningham?
Yes, motion carries.
Thank you. Stepping into new business, the first item you haven't heard yet is number 17-69 for the property located at 2635/Pine Court. The city wishes to withdraw this case due to vacancy. If a property is vacant, then the water violation does not continue. This property is listed with it, that it is occupied with no active water source, and due to the property being vacant, not occupied, the city wishes to withdraw this case.
Okay. Next case.
Okay.
You look confused, Member Grant.
Yes, I am, but that's a normal state for me, don't worry about it.
The next case, number 17-70, for the property located at 3205 Royal Oak Drive is the same as the last. The city wishes to close this case as it is vacant.
That is the correction. That's how it gets corrected. If there's nobody living there, there's no violation.
I believe you.
So far.
So who paid the last bill?
It's kind of like we'll have cases where if they get a permit, that corrects the violation.
Okay.
The next case on your agenda, number 17-71, the property located at 220 LaGrange Avenue. Again, the city wishes to withdraw this case as the property is sold, the water has been paid for, and the property is in compliance.
A good one.
Very much so.
Good.
The next case, 17-73, for the property located at 623 South De Leon Avenue. The city is working on solutions and wishes to continue this case for 1 month.
So moved.
Second.
Motion by Joe, seconded by Ashley. Any discussion? Roll call vote.
Member Grant?
Yes.
Vice Chairman Bell?
Yes.
Member Richardson?
Yes.
Member Edens?
Yes.
Chairman Cunningham?
Yes, motion carries. Going back one case, just so the public can also understand, on the occupied with no active water source, the closure came because they sold it, and then you collected the lien.
For 220 LaGrange, yes, the new owner paid for the water debt that was owed to the city.
Okay, so that's the bright side.
That's the best solution possible.
Okay. So the city got its money, and we're off and running.
I never understood that.
Which?
The new owner of the property is still responsible for that. Previous owners.
That's why they have title insurance.
Negligence.
When you purchase, I would venture the guess that the price was reduced accordingly in order to pay it off.
I don't know what type of sale happened between the two property owners, the former and the current. I don't know if it was a tax, I can't recall if it was a tax deed sale or not, but if it was a tax deed sale and there was surplus, the city has priority, and the city often gets paid in that fashion. It depends on the nature of the transaction, which I don't have the information of in front of me at this time.
And if you close a piece of property and you have title insurance, they're going to identify all these things before you get to the closing table.
I understand all the liens and stuff that could be
Okay.
involved. Yeah, I understand all that.
So whoever paid it off went into it eyes wide open, hopefully. And there probably is a case where they got a good deal on it, and it was worthwhile to pay off the liens or other things Because I know investors will buy properties that way, to flip them.
I should be taking notes, right?
Yes, sir.
If that's
And
the business you're interested in.
Don't get caught with one.
Sorry, bad joke.
The next case that's listed on your agenda, 17-74, for the property located at 300 North Washington Avenue. The city wishes to close this case due to compliance.
What's the difference between withdrawn and closed when there's a compliance?
If the board does not hear the case, then the city has the right to withdraw it prior to presentation to the board. Once it gets presented to the board and we make any kind of finding, then it's a different dog to work with. It's who has jurisdiction. City has it until we take jurisdiction. Then when we turn it back over at the end of the case, then the city's got it again.
Okay.
So you'll find sometimes the board will choose not to turn the case over so that we can remain in jurisdiction.
Okay.
Not too often, but.
And
Yes.
once any case is continued, you must vote on it. Before it gets to that point, then it's my jurisdiction to control what happens with those cases.
Okay.
The next case on your agenda is 17-75 for the property located at 729 Lucky Street. I'd like to invite Officer Hutchings to provide testimony. Officer Hutchings, did you have an opportunity to inspect the premises at 729 Lucky Street?
Yes, I did.
And when was your first inspection?
My first inspection was in 10/13 of 2016.
And did you find this property in violation of the Titusville Code of Ordinances?
I did.
What was the nature of the violation?
The nature of the violation was going to be overgrowth and debris, 1326 and 1223.
Did you provide notice of the violations to the owner of record by first class and certified mail, as well as posting the same on the property and at City Hall?
Yes, I did.
And do you have the proof of mailing and an affidavit attesting to the notice?
I do.
Can you please submit the proof of mailing and an affidavit as to notice into evidence as Exhibit Number 1? And did you reinspect the premises to determine if the property was in compliance with the violations as cited?
I did.
And did you take photographs of the property?
I did.
When did you take this photograph?
This was taken on 6/12/2017.
And let's see what this photograph looks like.
Well,
Can you tell us what does this photograph depict?
What is that?
This photograph depicts the debris and the overgrowth. The time frame, let me explain what the threshold. There actually was, in fact, some progress. This is actually a rewrite due to reinspection. And so once I saw no progress, then it was time to obviously take it one step further.
Is this a vacant lot?
Yes, it is. The importance of getting it back into is there's homes surrounding this lot, especially right next to it, and a couple of empty lots there as well, which are being addressed, is they keep their frontage and their side yards in very, very nice condition.
Can you please submit the photograph as evidence as Exhibit Number 2?
And we are now in the season.
Yes,
We
sir.
have the mix.
Why wouldn't we go to that post office box because of like coming out of those woods? I mean, out of those weeds.
Do what now?
I said I wouldn't want to go to that mailbox with stuff coming out of them weeds.
Yeah,
And
but we're finally getting growth because we got two parts. The sun, now we have the
Well, I don't
rain.
care about the rain, but I just don't want anything coming out of there.
Good Lord.
based upon your inspections, did you file a complaint?
Yes.
Did you issue a copy of the complaint and a notice of this hearing to the owner of record by first class certified mail posting the same on the property and at City Hall?
Yes.
Do you have an affidavit as to this notice?
I do.
Please place the proof of notice and affidavit into evidence as Exhibit Number 3.
That's definitely more than 12 inches high.
definitely. This is a vacant lot, you say, no home, nothing like that, right? Just a vacant lot? Okay.
Yes, sir.
Do you have pictures that show the junk and debris as well as the overgrowth?
It's probably not depicting as such. There's junk and debris. If you look right by the mailbox area,
Okay.
debris being classified, dead foliage, whether it be large amounts of trash, small amounts of trash, the entire lot needs to be cleaned up.
Okay.
It's a little bit exaggerated due to this last rain. be honest, it didn't look near that bad, but I can see going forward what it's going to look like here in the next month.
And do you have a cost recovery statement detailing the cost incurred in bringing this case before the board?
I do.
And what is the amount?
$375.04.
Please place the cost recovery statement into evidence as exhibit number 4. Thank you.
Just a quick aside, but it pointed out in this case, from April till May, we almost doubled in the number of overgrowth items, and this is the season. Because that's still the number one violation in the city of Titusville is overgrowth.
Yeah, well, I got 2 on my block.
All righty, anybody had any questions or anything on this one? If not, please, motion.
I'll do it.
Good, Pat?
I move that the board issue the following findings of fact in case number 17-75 relating to the defendants Yogi Treviati and Gita Treviati. The defendants were properly notified of violations as alleged in the complaint. The defendants are the owners of or in possession of the real property located at 729 Lucky Street, Titusville, Florida. The defendants are in violation of the following provisions of the Code of Ordinances of the City of Titusville. Section 17-73. Oh, no, wait a minute, sorry. Section 12-23, junk and debris, and Section 13-26, overgrowth.
Second.
Motion by Pat, seconded by Joe. Any discussion? Roll call vote, please.
Vice Chairman Bell?
Yes.
Member Richardson?
Yes.
Member Grant?
Yes.
Member Edens?
Yes.
Chairman Cunningham?
Yes, motion carries. Next motion, please.
I move that the board issue its order to correct relating to the defendants Yogi Triviati and Gita Triviati, adjudging the defendants to be in violation of the section of the Code of Ordinances of the City of Titusville as determined in the findings of fact. Giving the defendants until 9 a.m. on July 10th, 2017 to correct the violations to the written satisfaction of the code enforcement officer or to appear before the board at City Hall, Titusville, Florida on July 10th, 2017 to show cause why the violations have not been corrected and why this board should not proceed to impose a fine for the violations. The defendants are ordered to pay $375.04, which represents the cost incurred by the City of Titusville to bring this case before the board.
Second. Motion by Pat, seconded by RL. Any discussion? Will the city contractor address this one?
I believe it's already been sent on his list, yes.
Okay, so then they'll get another bill for that, correct?
After it's been done, yeah.
Yes. Okay. Roll call vote, please.
Vice Chairman Bell?
Yes.
Member Richardson?
Yes.
Member Edens?
Yes.
Member Grant?
Yes.
Chairman Cunningham?
Yes, motion carries. Next case, please.
The next case on your agenda is 17-76 for the property located at 1620 Hilldale Road. And again, I'd like to invite Officer Hutchings to provide testimony for this case. Officer Hutchings, did you have an opportunity to inspect the premises at 1620 Hilldale Road?
I did.
When was your first inspection?
The first inspection was made on 4/3 of 2017.
And did you find this property in violation of the Titusville Code of Ordinances?
Yes.
What was the nature of the violation?
13-73 inoperable vehicles.
And did you provide notice of the violation to the owner of record by first class and certified mail as well as posting the same on the property and at City Hall?
I did.
And do you have a proof of mailing and an affidavit attesting to this notice?
I did.
Please submit the proof of mailing and affidavit as to notice into evidence as exhibit number 1. And did you reinspect the premises to determine if the property was in compliance with the violation as cited?
I did as of this morning.
And did you take a photograph of the property?
Photograph was taken on 6/6/2017, to which reflects the same condition as initial inspection.
And is this photograph a fair and accurate representation of the property as of today's inspection?
Yes.
Do you have any other photographs?
I do. Something a little bit closer.
Oh.
It's floating.
It's on hubcaps.
Please submit the photographs and evidence as exhibit number 2.
I was going to ask how we knew it was inoperable, but pretty sure we know now.
And based upon your inspections, did you file a complaint?
Yes.
Did you issue a copy of the complaint and a notice of this hearing to the owner of record by first-class certified mail posting the same on the property and at City Hall?
Did.
Do you have an affidavit as to this notice?
I do.
Please submit it into evidence as exhibit number 3. And do you have a cost recovery statement detailing the cost incurred in bringing this case before the board?
I do.
And what is the amount?
$410.26.
Can you please submit the cost recovery statement into evidence as exhibit number 4?
You might be a redneck.
I'm sorry, what was that cost recovery statement amount?
$410.26.
Thank you. Just a bit. Just a bit.
Well, I'm thinking of Glenn. Did Pat speak to you?
No, not yet.
Not yet. Pat needs to meet
I
with
need
you
to
before
speak
you
with
leave
you
today.
afterwards.
We're good. Does the board have any questions about this case?
No.
Thank you.
Anybody? We're in good shape.
The other one's leaning. One's floating, the other one's leaning.
Mm-hmm.
The leaning tower truck.
Who would like to make a motion?
I can do that one too.
All right, Pat.
I move that the board issue the following findings of fact in case number 17-76 relating to the defendant Sylvia Chin. The defendant was properly notified of the violation as alleged in the complaint. The defendant is the owner of or in possession of the real property located at 1620 Hilldale Road, Titusville, Florida. The defendant is in violation of the following provision of the Code of Ordinances of the City of Titusville, Section 13-73, by reason of an operative vehicle being prohibited.
Second.
Motion by Pat, seconded by RL. Any discussion? Roll call vote, please.
Member Richardson?
Yes.
Member Edens?
Yes.
Member Grant?
Yes.
Vice Chairman Bell?
Yes.
Chairman Cunningham?
Yes, motion carries. Next motion, please.
I move that the board issue its order to correct related to the defendant Sylvia Chin. Judging the defendant to be in violation of the section of the Code of Ordinances of the City of Titusville as determined in the findings of fact. Giving the defendant until 9 a.m. on July 10th, 2017 to correct the violation to the written satisfaction of the Code Enforcement Officer or to appear before this board at City Hall, Titusville, Florida on July 10th, 2017 to show cause why the violation has not been corrected and why this board should not proceed to impose a fine for the violation. Defendant is ordered to pay $410.26, which represents the cost incurred by the City of Titusville to bring this case before the board.
Second again.
Motion by Pat, seconded by RL. Any discussion? Roll call vote, please.
Member Edens?
Yes.
Member Grant?
Yes.
Vice Chairman Bell?
Yes.
Member Richardson?
Yes.
Chairman Cunningham?
Yes, motion carries.
Next case is...
It had one notch on it. I turned the ringer off, but not the message thing.
It's okay.
I apologize.
You're excused. Case number 17-77 for the property located at 2143 Harrison Street, 7D. The city wishes to withdraw this case due to compliance. For case number 17-79, the property located at 1760 TD Lane, the city wishes to withdraw this case due to compliance. And lastly, case number 17-82, 44425 Stewart Ave. Again, the city wishes to withdraw this case due to compliance.
You're so good, Dad.
She's a nice
I don't know
lady.
how you line up all those nice bonuses at the end.
I don't do it, it's the officers that I work with, it's not their fault at all.
Not your fault, but you'll take the credit. Yes, yes. Take it.
Board Attorney's report when you're ready.
Ready. I have a report. I have 5 final judgments to bring to the board's attention, which I recommend you turn over to the city office in their discretion to commence foreclosure action or any other action that is reasonable to achieve code compliance. First case, 16-124, Defendant Stephen R. McCaslin and Angela DiBernardo McCaslin, property located at 798 Florencia Circle, Titusville. Final judgment was dated December the 12th, 2016. The violations on the property were Code Section 18-11, nuisance pool. Property Maintenance Code 6109, 303.1, lack of pool maintenance. Subsection 303.2, improper enclosure. Fine was imposed of $100 per day per violation, total $450 per day, to commence on December the 12th, 2016 through today's date, June 12th, 17, 183 days at $450 per day. Total accumulated fine to date, $82,350. Cost previously assessed, $479.95. Total fine and cost to date, $82,829.95. The next case is 16-129, Defendant HSI Asset Corporation Trust, 2006 HEI. Final judgment was rendered on January the 18th, 2017. The property with the violation was and is located at 1607 Palmetto Street, Titusville, Florida. The violations as determined by the board, 6-109, subsection 304.1.1, unsafe conditions. Fine imposed, $250 per day, to commence on December 16th, 2016 through today's date. Totals 179 days at $250 per day. Total fine, $44,750. Cost previously assessed, $356.68. Total fine and cost to date, $45,106.68. Next case, 16-133, Defendants Clara A. Walsh, Life Estate, and Carol W. Garrett. Final judgment, January 18, 2017. Property with the violation located at 1475 Thornton Avenue, Titusville. Violation found by the board, 1326, overgrowth, 6-109, subsection 304.13, windows and skylight. Fine imposed by the board, $75 per day per violation, total $150 per day, to commence on January the 9th, 2017 through today's date. 155 days at $150 per day, total fine $23,250. Cost previously assessed, $427.12. Total fine and cost, $23,677.12. Next case, 16-135, Defendant, Mark C. Cameron. Final judgment, same date, January 18, 2017. Property location with violation, 1690 South Park Avenue, Titusville. The violations at that property consist of Code Section 6109, subsections 108.1, unsafe structures, general. 108.1.3, structure unfit for human occupancy. Subsection 110.1, demolition. Subsection 305.1, general interior structure. Subsection 309.1, infestation. Fine of $75 per day per violation. Total per day, $375 to commence on December the 16th, 2016. Total number of days, today's date, 179 days at $375 per day. Total fine, $67,125. Cost, $462.34 that were assessed. Total fine and cost to date, $67,587.34. The last case is case number 16-125, Defendant, Francis M. Ferrellulo, property where the violation exists, the property address is 2730 Redwood Avenue, Titusville. Final judgment, January the 18th, 2017. Violation which occurred and is apparently continuing, 6-109, subsection 102.2, occupied with no active water source. In that case, the fine was set to be the previously assessed cost only in the sum of $479.95. I recommend all 5 cases again be turned over to the City Attorney's Office with the Board's permission.
So moved.
Second.
We have a motion by Joe, seconded by Pat. Any discussion? Roll call vote, please.
Member Edens?
Yes.
Vice Chairman Bell?
Yes.
Member Richardson?
Yes.
Member Grant?
Yes.
Chairman Cunningham?
Yes, motion carries. Ashley, you can see what $100 a day or $75 a day can do if it's ignored.
Crazy, they are crazy.
Anything else under Board Attorney's report?
No further report.
Very good, sir. City Attorney?
This is not really related to the Code Enforcement Board, but last Saturday we had our grand opening of the Splash Park.
Yay.
And I just wanted to let you all know that it's open and it's one of our newest features of the city of Titusville, so hopefully you can go check it out.
Were you there opening day?
Unfortunately, I was out of town, so I'm going to be on the list of people that need to go check it out, and I'm looking forward to it.
Okay, I don't get out very much, so where's the splash park?
Sandpoint Park.
Oh, in the
Very good.
pavilion.
Okay.
Boy, you don't get out any, do you?
My wife won't let me.
Well, tell her to let loose your leash.
I have a 3-year-old, so I'll be a frequent inhabitant over there.
Code Enforcement Manager?
No report, sir.
No report. Same from the chairman. Any board members have anything to report or talk about?
I just would like to say one thing. It doesn't have to do with anything we have in front of us right now, but I saw something on the local media, whether it be fake news or not, that's where I saw it. That 50% of the houses the structures are building in Osceola County are investor houses. And the story went on to say that they're rented by Airbnb and other businesses 1 week. And we just saw something where we're limited to 2 months or 3 months.
We're limited to 4 times a year, no more than 4 times a year, and no less than a certain amount of time.
And I think we may be facing this.
Vacation rental businesses is a hot button issue. It's very political. It's something that the legislature has discussed for the past several years, and there are certain communities throughout the state of Florida that have grandfathered ordinances that were written before the state preempted municipalities from writing further regulations. So there's a lot that goes into vacation rentals, and I'm sure if you looked for it, now that you're aware of the issue, you can find stories about this issue all over the state, from Miami to Pensacola, and there's varying opinions on them, but the idea behind the vacation rental prohibition of having frequent turnover in your property is that the community, the neighborhood, does not enjoy having that happen in their community. That's why it is a contentious issue.
Well, a lot of those neighborhoods, they interviewed some of the residents that live there full-time. That is quite an issue. But there's a lot of that going on in adjacent counties and communities.
Also, they don't pay the tax that's due. You rent property, you pay tax. On the commercial basis, anyway.
There's a built-in in real estate now, there's a luxury tax on any lease that's less than 7 months. So, I mean, it should automatically be there,
I
truthfully.
think that's why the state got involved. It was a money issue.
Well, I must say our new mall is coming along just splendidly. Isn't
Yes.
It looks good.
Yes, it does. There is a lot happening in this community, and hopefully it'll go along at a reasonable pace and not the break type that just doesn't do the community any good. That's just an opinion. Anything else to bring before the board? We stand adjourned. Thank you very much for being here.